So first of all, let me sincerely thank to the Central European Academy and the organizers of this event for having us, for involving us in this opportunity for dialogue and exchange. I believe I can also extend these thanks on behalf of Professor Crema. As anticipated, Professor Crema and I will focus on the relationship between international law and constitutional law in the Italian legal system. Our presentation will be divided into parts. In the first one, I will outline the fundamental pillars embedded in the Italian Constitution on which the regulation of the relationship between international law and the Italian legal system is built. And in the second part, Professor Crema will focus on the main developments emerging from the case law, especially of the Italian Constitutional Court. Well, when addressing this topic, I think it is essential to start from a basic premise. The importance of international law in the Italian legal system can only be appreciated in light of the experience of the Second World War. That historical context by members of the Constituent Assembly who conceived the new constitutional order as a clear break with the legacy of fascism and as a strong post-war commitment to internationalism. And the outcome of this choice is visible in the structure and content of the Italian Constitution. And the Italian Constitution, entering into force in 1948, does not contain a single systematic chapter. Systematic chapter on international law. Rather, openness to the international legal order is embedded throughout the constitutional text. In the fundamental principles, in part 1 of the Constitution on rights and duties, and in part 2 on the institutional framework. From these provisions, it emerges that despite a strong openness to the international dimension, the theoretical model adopted by the Italian legal system remains a dualist one. International and domestic law are conceived as distinct legal orders, even though they are closely connected. And this dualist approach is particularly evident in the constitutional rules governing concerning fundamental principles and procedures. And among them, two provisions are pivotal. Article 10 and Article 11 of the Italian Constitution. Both these provisions are located among the fundamental principles, which Italian legal doctrine and the Constitutional Court itself regard as forming the core of Italy's constitutional identity, to the extent that they are considered not subject to constitutional amendment. Specifically, Article 10 provides that the Italian legal system conforms to the generally recognized principles of international law. And this clause has been interpreted as establishing the automatic incorporation of customary international law. It does represent a sort of permanent channel of openness toward the international legal order and places customary international law at a high level within the domestic system of sources. But I will deepen this point later on. Turning instead to Article 11, it authorizes limitations of sovereignty on condition of equality, whenever they are necessary to promote peace and justice among nations, and commits Italy to promoting international agreements and organizations pursuing those aims. I also would like to stress that it is precisely this provision, Article 11, that in the absence of an explicit European clause has also served as the constitutional basis for Italy's participation in the European integration process. on the basis of Article 11, described as the Grundnorm of the relationship between the Italian and European legal orders, the founding European treaties, but also the subsequent treaties, were approved by ordinary law, and the provision has been interpreted as an authorization or even a mandate to join supranational organizations. Constitution also address international law, also in the part of the Constitution devoted to the institutional framework and procedures. In this context, in particular, the Constitution regulates the entry of treaty law through procedural provisions. Unlike customary international law, treaties does not become part of the domestic legal order automatically, but their incorporation requires an act of the state. In particular, according to Article 80, a parliamentary authorization is required for the ratification of treaties of a political nature, those involving arbitration or judicial settlement, territorial changes, financial burdens, or new legislation. Ratification is formally performed by the President of the Republic under Article 87, but with the counter-signature of the government, which bears political responsibility. And moreover, Article 75 excludes laws ratifying international treaties, as well as laws giving them execution, from the scope of the abrogative referendum, confirming their special constitutional relevance. Actually, remaining for a while on the level of procedural mechanism, when discussing the nationalization of international law within the Italian legal system, a fundamental distinction must be drawn between the ordinary and the special methods of incorporation. Although not explicitly codified in the Constitution, a consolidated practice has developed whereby international law may enter the domestic order through these two mechanisms. The ordinary method consists in legislative transformation, so Parliament enacts a statute that implements and adapts treaty obligations. And the special method, by contrast, is based on referral to an order of execution, usually contained in the ratification law, which makes the international text directly applicable. Article 10 itself is the paradigmatic example of this second technique with regard to customary international law. These different methods have important consequences for judges. Because where incorporation occurs through transformation, courts primarily apply the domestic statute. When it occurs through referral, judges must apply and interpret the international norm itself, taking into account its evolution within the international legal order. Well, against this backdrop, which I've tried to summarize, it must be emphasized that over time, the original dualist framework has undergone what many scholars describe as a process of tempering. A crucial aspect of this evolution concerns the hierarchical rank of international norms within the system of sources, a matter on which the Constitution is silent. Nonetheless, according to a general principle, international law acquires the same rank as the domestic act through which it is incorporated. On this basis, customary international law, by virtue of Article 10, is generally considered to have constitutional rank and can serve as a parameter for constitutional review. Treaty law, by contrast, usually has the rank of the incorporating act, typically an ordinary statute, or even that of a secondary source of law, if the order of execution is contained in an administrative act. This apparently simple scheme, however, has raised crucial questions. First of all, can international law conflict with constitutional law? And if so, could the Constitution be overridden by applying the so-called chronological criterion? And where treaty law has the rank of a primary source, can it be displaced by subsequent legislation, or must other criteria prevail? In answering this question, the Constitutional Court has played a decisive role. On the one hand, it has affirmed the dualist premise. Indeed, customary international law remains part of an external legal order, and moreover, it is subject to the fundamental principles of the Constitution. And in accordance with the doctrine of counterlimits, these supreme principles forming the core of constitutional identity prevail, even over international norms. On the other hand, with respect to treaties, the court has developed a more nuanced solution. Although treaties are incorporated through ordinary legislation, they enjoy a special hierarchical status. This approach has also found constitutional confirmation in a reform in 2001, the reform of Article 117, which requires all legislative powers, both state and regional, to be exercised in compliance with international law and EU obligations. As a result, conventional international law has acquired an infra-constitutional but supra-legislative rank. It remains subordinated to the Constitution, but prevails over ordinary statutes. And conflicts are therefore resolved by the Constitutional Court, which reviews domestic legislation in light of international obligations through the constitutional filter of Article 117, treated as an interposed parameter. A paradigmatic example of this development in the court's case law is the court's case law on the European Convention on Human Rights. But it is precisely on the role of constitutional case law, with specific reference to the doctrine of counterlimits and to the hierarchical rank of international law within the system of sources, that Professor Crema will focus. Thus, I am pleased to give him the floor.
Thank you, Benedetta, and thank you. I join the thanking to the organizers and to the participants in this online event. I missed the break. I don't know how many people were together, but there was a long break between the first panel and the second one. I bet that the most interesting conversations happened among those who were in the same place in those minutes in which we didn't see each other. So I will cover, and I missed those moments. I will cover a few cases just to go through certain juicy issues that already emerged during the first panel, and in part also in the presentation. For example, David's presentation covered very many of the issues that EU law and Italian law had to deal with, in part because he quoted EU cases that therefore bind also Italy, in part because the cases he referred at the national level had some kind of mirror in precedent decisions of, in this case, the Italian Constitutional Court. So I would not spend too much time on the complex relationship between the first relationship between EU law and Italian law, because now we are in a totally different story. After the push to integrate the domestic legal systems and the EU legal system in a sort of attempt to destroy the crust of sovereignties of our companies having monopolies, of our legal systems being formally dualist and proudly deferent to sovereignty rather than the international cooperation, we had a push, with the push establishing primacy of EU law. Now the push came back, not just for political reasons, but also because of an adjustment. The swing goes in one direction, often in law, and then comes back, not because of political reasons only, but also because the byproduct of the first push is more evident, and we have to deal with that too. So one of the big cases that I listed there, and it's very famous, is the Taricco saga, is the last one. And the Taricco saga covered a fraud about VAT that was affecting EU institutions too. And therefore, an Italian judge in 2015, if I'm not wrong, raised a concern showing the conflict between the statute of limitations in our criminal code and interest under EU law of having an effective protection of the EU financial interest. So the Italian judge deferred the problem to the ECJ. The ECJ said that he was right, that there is this interest, but our constitutional court said that actually statute of limitation embeds a fundamental principle that cannot be derogated by the EU law, in particular the nullum crimen, nulla pena sine lege, the principle of legality. We cannot remove a statute of limitation and then go back and tell people that were relying on a statute of limitation and put them to jail. So there was a second chapter, and the Italian Constitutional Court basically built a theory of counter limits very strongly similar to the very same reasoning used under Article 10 of the Italian Constitution that my colleague Vimercati quoted about international law. What was the story of Article 10? Article 10, as said, magari, Benedetta, can you go back just to Article 10? We didn't share the PowerPoint to be smooth, but now I regret it because I don't have the control of it. So Article 10, there it is. Article 10 incorporates international law into our legal system. And we are not, as Italians or European, heavily integrated with the international legal system. We are heavily integrated with the EU legal system. So under Article 10, quite the contrary, we have that international law, custom international law, becomes constitutional principle in Italian law, while EU law is incorporated through the acts incorporating the treaties, therefore ordinary law. That's a paradox. The EU law in constitutional terms comes second in the Italian constitutional terms compared to customary international law. So let's see 1 second how Taricco jumped on the Article 10 case law, because Article 10 already in 1979 was interpreted not as an absolute principle or constitutional law in Italy, because the incorporation of a certain rule of international law would have conflicted with other fundamental rules, I think right to defense, that would have been affected by the incorporation of an international customary norm. This was 1979. So the international principle conflicted with other constitutional conflicts, and the Italian Constitutional Court decided to be the arbiter, the final arbiter on this conflict. The same happened in 2014 with the decision on the immunity of Germany, the famous ICJ, the International Court of Justice decision, when the 238 decision of 2014, the Italian Constitutional Court had to decide, the 238 of 2014, there we go, the penultimate, had to decide whether to enforce a decision of the International Court of Justice and the UN Charter that attributes binding effect to these decisions into the Italian legal system. Relying on Article 10, we should have bent our will to, I'm talking in a Hegelian terms, now our will to the supranational authority, in this case the International Court of Justice, but we decided not to because of a conflict with a jus cogens norm. So the International Constitutional Court decided to engage the relationship, the complex relationship between peremptory norms of international law and immunities, explaining that complicated relationship could not give effect to the International Court of Justice decision in our constitutional landscape, because that would have affected a superior norm. The Taricco saga happens right after this interpretation of Article 10, and our Constitutional Court incorporated the same mentality, the same way of reasoning also about EU law, putting the core principles of the Italian constitutional legal system at the center and contrasting the supremacy of EU law. Now, is this just another chapter of sovereignism versus internationalism, cosmopolitanism? I don't like to frame it that way, just because, as I said, the swing goes up and the swing goes down, and it's normal to have adjustments and limits and counter limits keep shaping each other. It is very evident, this swing, if we look, and then I will conclude in the last 2 minutes, if we look at what is the the ICC acronym we used in the paper stands for Italian Constitutional Court, but for an international lawyer, as I am, is International Criminal Court. So sometimes when I read the notes and I see that acronym ICC, the term slips out. So the Italian Constitutional Court in 2007, when the swing was pushing towards the full international cooperation, there was the American peace, the Pax Americana, and the world seemed happy. And the history was ended. In 2007, in 2 twin judgments, the 348 and the 349, the Italian Constitutional Court affirmed that the European Convention of Human Rights is a parameter under Article 117 of our Constitution, both as a treaty, so we have to incorporate in our constitutional landscape the European Convention of Human Rights, and incorporating also the way it is interpreted by the European Court of Human Rights. So there was a very strong push, basically, to incorporate a strong vision of Article 117 into our constitutional decision making. That incorporates, it gives a special place to the ECHR and the way it is interpreted. However, already in 2007, applying the Lanzarote Convention against sexual exploitation and sexual abuse, or the highest civil jurisdiction, the Court of Cassazione, had a different opinion and said that not always a treaty protecting human rights, in this case, still under the Council of Europe cooperative umbrella, cannot be used as a interposed parameter under Article 117. And again, in 2018, with the case 120 and 198, the Italian Constitutional Court had to answer the legal question of whether to incorporate the European Social Charter and the way the treaty body interpreting and applying the European Social Charter had to be incorporated into our domestic constitutional legal system. The court, in these cases, developed a lens to analyze the issue that little by little refined a position, and on this a conclusion, that there is not a single way to look at the relationship between international law and Italian constitutional law. That the Italian constitution doesn't frame one way to look at the supranational legal system, but it is rather in the interpretation of the treaty and of the constitution that we will find the answer. In particular, we have to look if the treaty attributes binding effect to the to the court taking care of the application of the treaty. Second, if the treaty attributes the power to interpret the convention, the supreme authoritative power to interpret the treaty. So we have to imagine a matrix in which we have both the treaty and the Italian principles, And it's from the mashup of these regulations that we will find a likely outcome of our Constitutional Court in deciding whether to include international legislation and international judicial decisions into our legal systems or contest it. Thank you.